Now let's turn to the pending case, slide 7, California versus Texas, originally called Texas versus the U.S., and we'll describe what happened there in a moment. Again, in the context of the overall set of issues involved here, you may remember that when the Republicans sought to repeal the Affordable Care Act, and they got to the point where Senator John McCain walked back onto the floor on this in the 2018 and gave the famous thumbs down. That repeal effort failed. What the Republican Party leaders then did was move to a fairly crafty strategy. They what's called zeroed out or eliminated the tax as defined by the Supreme Court in the National Federation of Independent Businesses case in 2012. They zeroed out that tax and then sued. This case was actually brought in Texas, arguing that without a tax to make it legitimate, the mandate was simply a command, and that command was unconstitutional. It was illegitimate. We should note that these challenges were filed and were litigated through two courts prior to the current pandemic. The trial court in Texas decided that the mandate was unconstitutional, as the plaintiffs sought, and ruled that the mandate was so inextricably bound with all of the other provisions of the ACA that it was all one interlocking mechanism, that it could not be severed, it could not be separated out, and therefore the unconstitutionality of the individual mandate meant that the entire statute was unconstitutional. That decision was appealed to one of the 11 federal courts of appeals, which heard the case and decided last December 2019 that in a split decision, that is, there was a majority opinion upholding the Texas court decision and a dissenting opinion opposing that decision, but all the issues now become much more challenging to sort of navigate. But the point is that the Court of Appeals said the district court wasn't careful enough in its analysis of severability, one other legal doctrine that's been around for a long time, and sent it back to the trial court saying, go sit down with the 80-page statute and analyze for us more carefully and more clearly what is or is not severable and why. Before that actually happened, the case was appealed to the U.S. Supreme Court, and the U.S. Supreme Court accepted the case. The Supreme Court, in situations like this, when asked to by the parties, can grant expedited review. That is, fast track it, get it before the court quickly, so the issue can be decided quickly because the issue is of that degree of importance. The Supreme Court rejected that request and set it down in its docket for the fall of this year, when in fact it will be heard. We don't have any idea what, if any, impact the election schedule had in their decision making. We don't know what, if any, impact the pandemic had in their thinking. We just know that it will not be heard quickly in which case, had it been accepted, it might well have been or an oral argument either already finished or oral argument in the next few weeks, but that's not what is going to happen. What has happened is that the name of the case has changed because although the Trump administration has changed its position in this litigation, it started out from one level of opposition to the ACA to another level of opposition to the ACA. It started out making the unusual decision of not defending the statute, which is almost always the case. If a federal statute is challenged, the administration, the Department of Justice, defends the law on the principle that the law was duly enacted, and it's just the government's job to defend its congressional decision making. The Trump decision, the Trump administration decided not to do that, and when the court was as the court was going up to the Supreme Court, 21 democratically controlled states, as well as the use of the United States House of Representatives, intervened in the case. So it requested and were granted the right to intervene in the case in order to defend the ACA, arguing that the court should uphold it. So what was once Texas versus the United States is now California versus Texas, California being the lead or first state to seek to intervene, but there are actually 20 other states with it in the House of Representatives. As a result of the case being pending, and that has been the case for the last 10 years, the zealots who are opposed to the ACA get to continue to articulate the rhetoric that the ACA is doomed, and for a variety of reasons, that is something they think is important to announce. And one of the things that appears to result in is just increased uncertainties for vulnerable people, for healthcare providers, and for insurance companies. That is the status of where we are right now. Turning to last slide 8, well, what will happen? Again, these are not good bets because no one really knows what's going to happen. Even were the pandemic not the sort of disruptive force that it is. As with any case, the people that initially brought the case could decide to withdraw or to dismiss the case and withdraw their request. That seems to be an unlikely scenario. Congress and the administration could amend the statute again to drop the language which essentially says which creates the individual mandate, says everyone shall obtain, because one of the interesting facts, or apparent facts, we don't know for sure, but it appears that the elimination of that tax or penalty has not affected the numbers of people that are obtaining insurance or not obtaining insurance. The Supreme Court, what might the Supreme Court do? It has any number of different options. It can answer the question by answering a separate non-substantive question. That is, it could say, for example, that one or more of these parties before it do not have standing, which is a traditional, again, legal principle about who has a legal right to bring a matter before the court. It could decide that the case is what's called non-justiciable, or a political question. It could say, this is not for us to decide, this is for the political branches of government to decide, or other parts of the government. You may recall last year when the case went to the Supreme Court, the most recent case on the question of the constitutionality of political gerrymandering, the court stepped aside the question and said, this is not for us to decide, this should be decided at the state level, and the state judicial courts should be the ones asked to get involved. It could decide the case on this severance question. It could answer the case one way or another about whether the the unconstitutional mandate can be separated from the law. It can also decide, go back and answer the question of itself of whether it is an unconstitutional mandate. It can be creative, and I use that term specifically to describe the sort of new areas that the court might go in if it chose to reach a particular outcome. The use of the tax principle back in 2012 was a fairly unusual step for the court to take. The court is not afraid of taking unusual steps in unusual theories to reach particular outcomes. You may recall in 2013, the court used a novel interpretation of the Equal Protection Clause to strike down the some critical provisions of the Voting Rights Act of 1965. In the year 2000, it used an unusual set of analyses to stop the recount in the Florida election issues around the presidential election. We don't know what the Supreme Court's going to do, but what's clear is that it may or may not, but the possibility exists that the ACA will not exist after the Supreme Court issues its ruling. It seems to me, in closing, that those of you studying public health have the opportunity to decide for yourselves whether or not what is going on here is primarily about healthcare issues, systems reform, public policy, or what's going on here is about partisan politics. To me, the reality that from everything that I can see, there is no statute, there's no legislation waiting in the wings with verifiable components which will deal with the questions of the uninsured, the pre-existing conditions, the structural financial issues, that there's no replacement, and that itself is an important factor in having how you look at the question of this litigation. But in the light of the pandemic, I think the whole question becomes both more complex and more simple, and to my mind, certainly one that raises issues that are fairly called anxiety. I hope this has been helpful. Perhaps Professor Dewar can set up a mechanism online. I'd be happy to entertain questions or comments or criticisms about my thoughts on this area, and perhaps we'll get to continue this discussion. Take care of yourselves.